Hey, good afternoon. Coming to you from the studio doing this last bit on this deep dive into Texas Family Court protective orders. And these are this video series. We've been talking about the one that a private citizen brings under the Texas Family Code, and there's certain provisions that apply that govern, and we're talking about what happens after a protective order is entered. We've talked about the hearing on the protective order, and I'm going to dive into that just a little bit more. It's a hearing to the judge, which is often, in my opinion, in a family case, most questions relating to possession, access, what have you, they go to the judge anyway. So the judge is the most appropriate person to make the rulings on the protective order issues. They really are the most experienced. You put 12 strangers who are not experienced in family law, and we would have a clog in the courts, and again, because the legislature has made these issues judge issues, it speeds up the process. So back to what can happen. Well, it's a civil burden of proof. And what does that mean in plain English? That means that we have certain, it's like a ladder. We have certain burdens of proof. We all know the burden of proof for O.J. Simpson, right? The murder trials. We see the documentaries all the time on television. It's a beyond all reasonable doubt. That's the highest rung on the ladder. Below that is clear and convincing evidence. That's the evidence that must be shown when the state is moving to take away your children. All right, clear and convincing evidence that the removal has to happen because the safety of the children, welfare, etc. And then below that, the civil burden of proof, which is the greater weight of believable, admitted evidence, the preponderance burden of proof, right? The preponderance of the evidence. Doesn't mean 51%, means the greater weight of admitted, credible, believable evidence. And that can be a lot, and try to get that done in 20 minutes. And then below that is where we have our burdens of proof for the police officers who are, hey, you're wearing a ski mask at North Park in the summer. That's, there's suspicion there that they can investigate the potentiality of a criminal offense. But for this hearing, it's going to be the civil burden of proof. It's going to be a real short window. It's real compressed. You don't know what they got. They don't know what you got. And you're going to go in there, and somebody's going to win and somebody's going to learn. At the end of that, an order is going to be written up. Now, whether that order has all these restrictions that we talked about in the prior video segment, it's good for 2 years. There'll either be an order written up or an agreed order written up, but it's going to have some restrictions in there. And it's probably going to have some pretty heavy things for both parents, both spouses to deal with. And then last thing to talk about is how is it enforced and can it be modified? Well, it's enforced like any other order of the court. It can be enforced through the court's contempt power. So if you've got someone who's ignoring it, who's just doing whatever the heck they want, that order doesn't apply to me, make that order apply to me. Well, there's a remedy there. It's not an immediate remedy, but on 10 days, notice of contempt, you can have a contempt hearing. That order can be enforced through the detention of their civil liberty. In other words, they can be jailed, they can be put on probation, just like any other family court order. Right, enforceable through the court's contempt authority if it's not being adhered to. And yes, it can be modified, right? If that parent who is on the other end of a family violence protective order, let's say they finish their criminal charge, whatever that came from, that started the whole process, do their 12-step program, have a pocket full of sobriety chips, have a library full of completed self-improvement classes like battery intervention, parenting classes, co-parenting class. If they are really proactive, which I always recommend, always be proactive. When the government's in your life, don't wait for the government to tell you how to fix yourself. Be proactive. That will serve you better in the long run, even if you didn't do what is alleged. Being proactive is better than doing nothing. And that being said, that person who is the subject of the protective order can come back in and say, hey, look, Judge, I've done all this stuff. I've complied with all this. Can I please have some relief here, relief there? And the courts they will listen. They will listen to that, especially when they see self-improvement and being proactive. Anyway, Heavy subject. Thanks for hanging in there with me. Thanks for allowing me to be part of your team. Thanks for being part of mine. Please like, subscribe, and share. Leave me a question or comment on any video platform, and I will get back to you soon with more from the studio. Thank you so much.